Hey there, and welcome. Have you ever stopped to think about what actually happens, legally speaking, when you buy something? Today, we're deconstructing a concept that happens literally millions of times a day all around us, yet it rarely gets the scrutiny it deserves. In this explainer, we're going to look at the legal framework of a sale exactly like a recipe. By the end of our time together, you'll know the exact ingredients required to make any business transaction legally valid. So I really want you to think about the absolute fundamentals required to make a business transaction legally binding. When you hand over cash for a coffee or sign a massive corporate purchase order, what are the invisible legal building blocks that suddenly transform that interaction into a recognized contract?
Okay, let's dive into this. Looking at the Sale of Goods Act, I found it fascinating that there's a strict 5-ingredient master list for a valid contract of sale. To make it official, 5 distinct ingredients absolutely must be satisfied. 1. There must be at least 2 parties. 2. An agreement of sale has to be made. 3. The subject matter must be goods. 4. The transfer of that subject matter must happen from the seller to the buyer. And 5. There must be a lawful consideration known as price. So let's break these down one by one.
Our very first ingredient is that you must have at least 2 distinct parties involved. The Act defines these incredibly simply. The buyer is a person who buys or agrees to buy goods, and the seller is a person who sells or agrees to sell goods. Now, it sounds completely obvious, right? But establishing these 2 separate roles is the absolute bedrock of the whole thing. For example, you can't technically sell your personal laptop to your own sole proprietorship business just to create a tax loophole. There absolutely have to be 2 distinct legal entities acting as the buyer and the seller.
Next up, we need an agreement of sale and the transfer of the subject matter. Now, what's really interesting here is the distinction of what we're actually transferring. The legal term is property, but in this context, property means absolute ownership. It's not just a special property, which is basically the legal term for just borrowing or pawning something temporarily. No, you are transferring ultimate ownership. This can happen right away, which is known as a sale, or it can be an agreement to sell in the future, like ordering custom furniture to be built and delivered to you next month. Either way, absolute ownership must eventually transfer over.
And this brilliantly illustrates how immediate that transfer of absolute ownership can be. To see this in action, just imagine walking into a car showroom, paying cash, and driving away with a brand new car. In that exact moment, the title and absolute ownership of the goods transfer immediately from the seller to you, the buyer. The risk of loss now falls entirely on your shoulders, and the seller has absolutely no right to resell that car to anyone else. It's a done deal. Now, we really need to look closer at the third element, the subject matter itself. For this specific act to apply, the subject matter must strictly be goods. But what actually counts as a good? Well, the Act gives us a super clear definition. Goods are every kind of movable property. The crucial word there is movable. This entire framework deals exclusively with movable items, completely excluding immovable properties like land or buildings, as well as actionable claims and money itself. Let's anchor this theory to reality because the definition of movable property can get surprisingly interesting. It includes stocks and shares, but it also includes things attached to the land, provided they're agreed to be severed before the sale. Think of a standing crop of wheat. While it's currently growing deep in the ground, if it's sold to a merchant to be harvested tomorrow, it legally counts as a movable good. The intention to detach it is what magically turns it into a good.
And now we arrive at the final, mandatory ingredient. A contract requires lawful consideration. In a valid contract of sale under this Act, that consideration must specifically be money. This is legally defined as the price. So if you're trading a bag of wheat for a cow, that's a barter system, not a contract of sale under the specific definition. There must be a money consideration driving the transaction for it to fit the recipe.
So the crucial point is summarized by this strict, totally unbending rule: no consideration, no contract. It really is that black and white, folks. Without the price ingredient, without that lawful money consideration passing between the buyer and the seller, the legal sale simply doesn't exist in the eyes of this law. The whole structure just collapses without it. Okay, let's rapidly summarize the 5 key ingredients we've just deconstructed to make sure we've got this locked in. For a valid contract of sale, you absolutely must have 1. 2 distinct parties, the buyer and the seller. 2. An agreement of sale, whether immediate or set for the future. 3. The subject matter must be movable goods. 4. There has to be a transfer of absolute ownership, not just borrowing, from the seller to the buyer. And 5. There must be lawful consideration in the form of a money price. It's a beautifully logical system when you break it down like that, isn't it? Every single time you make a purchase, no matter how big or small, these five invisible legal pillars are standing right there holding the transaction up. So I'll leave you with this challenge. The very next time you buy something today, whether it's a quick cup of coffee or a new piece of tech, take a moment, look at the transaction, and see if you can mentally check off all five of these essential legal ingredients. Thanks for joining me for this explainer, and keep learning.